Hello, hello, hello. Yeah, hi Anu, you are able to hear me?
Yes.
Hello. And see the presentation as well? Presentation?
No, sir.
Give a thumbs down if you are not able to see the presentation. Hello. Anu? Anu? If you are not able to see the presentation, give a thumbs down. Okay, fine. So you are able to see the presentation, fine. Because I am not able to see on my screen over here the presentation per se on Microsoft Teams. But if you are able to see, then we'll proceed. Yeah, fine. So let's begin. And in a way, we are covering the chapter, the section B, module 6, which is about the laws and compliance in business valuations. And in that, in a way, we are looking at the various chapters. In that, first 3 chapters have already been done in the earlier sessions. So maybe we can start with the today's session straight away. And in that, basically we are going to cover the salient features. So we are looking at the laws and compliance in business valuation, the overall legal and regulatory framework which mandates the valuation per se, or there are specific provisions about business valuation therein. And so we finished the IBC code, which talks about how the valuation has to be done in certain events of liquidation or winding up, etc. And at a later point in time, thereafter in the next session, we saw the relevant provisions of Companies Act 2013, which mandates the valuations requirement, and more specifically section 247, which is about the registered valuer, what it means, who it means, etc. And thereafter we started off with then we finished the companies registered valuers and valuation rules as such of 2017, wherein in the last session we finished this chapter, and in that we had covered the various provisions that are required to be followed by the registered valuer in terms of the various valuation aspects. So today we will see another act or the regulatory framework which is about the salient features of SURFACE Act. Now this SURFACE Act 2002 on valuation provisions we will see, and then remains is the valuation standards, which is the last chapter in this module 6. Now unfortunately this module 6, though elaborately theoretical, has a weightage of only 5% in the overall scheme of things of your percentage of marks, and that's why depending on your kind of studies pattern, you can take a chance on this 5% in terms of what to study, why to study, and accordingly focus on the entire module 6. So let's begin. So the salient features of SURFACE Act 2002 on valuation. Now SURFACE Act per se, the full description is about it, called as the Securitization and Reconstruction of Financial Assets and Enforcement of Security Interest Act 2002. So this is the full form of the SURFACE Act, and in a way it's a long name of the act itself, and for that purpose is prominently it is the short form which is popular, SURFACE Act. or at times in corporate world it is called as the Securitization Act. And let's see the provisions that are applicable for this valuation from the valuation perspective. And let's see what all is covered. So to introductory part I am covering. So the SURFACE Act came into existence in 2002, which was enacted primarily to help the financial institutions manage and reduce the non-performing assets. So what happens typically while doing the lending and borrowing business, which is a prominent business of any what you can say financial institution, or for that matter bank also. Sorry, Anu, I got your message. The PPT is not visible. Unfortunately, I am not able to figure out why it is not visible, and maybe you can switch off and again log in and see whether it's visible. Obviously, I am not also able to see the PPT per se. Or if you know what is to be done, then maybe you can help me out. Or else what I can try, Yash, are you able to see the PPT? Yash? Let me just try. I'll ask for the technical help. Give me 2 minutes. Yeah, Anu and Rakesh, are you able to see now the presentation? हे बरोबर आहे इथे काय आलू नको.
इथे कॅमेरा आपण इन्स्टॉल केलाय ना, तो दिसतोय काय तुमचं एकदा चेक करायचं.
मग कर. हा कोण इकडचा आहे का तिकडचा आहे? तुमचा कॅमेरा आहे. हा अच्छा, तू बाजूला नवीन आलाय तो. हा ते जाऊन दे. हा आता काय केलंस तू? आयपॅडवरच आहे ना मी. असं का दिसतंय ट्रंकेटेड? ते बाजूला तिथे पण ट्रंकेटेड झाला, मोठा स्क्रीन होता तो. अनु, त्यांना ऐकू पण जात आहे, ती बोलताय ते मला ऐकू येत नाही, काहीच सगळं गडबड आहे. कोण फालतू करतं, हे बंद कर ना. Anu, can you just, or Yash, can you, Rakesh, can you just confirm you are able to see the screen properly and hear me also properly? Give me a thumbs up, both of you. Perfect, great. So visible and audible also. Great. So we'll start. Thanks, Avishkar. Yeah, so we are looking into the provisions, salient features of SURFACE Act on valuation, and this act predominantly came to support the financial institutions to manage and reduce the non-performing assets. So typically financial institutions, while doing the lending and borrowing business, at times may land up taking wrong decisions in terms of the assets to whom the it has been lent, and they may turn out to be non-performing assets, and for that purposes this Securitization and Reconstruction of the Financial Assets and Enforcement of the Security Interest Act came into existence. In a way, because of this act, it enabled the banks and financial institutions to sell bad assets to some special purpose vehicle, which is like called as assets reconstruction companies registered with RBI. So in a way, all those bad loans or non-performing assets were transferred to asset reconstruction companies, by virtue of which these asset reconstruction companies thereafter can take care of the securitization and so this is what is securitization, and thereafter take care of the reconstruction of financial assets. The act outlines detailed provisions for the formation and functioning of the asset securitization companies, or ACs or ARCs, either of these two categories. The RBI entirely regulates the activities of these companies, and it provides legal mechanisms for the protection of secured creditors like banks, financial institutions, etc. The Act empowers institutions to cover or recover loans by auctioning residential or commercial properties of the defaulters. So whatever non-performing assets have been there, and for that assets, whatever security has been kept with the lending institute or financial institutions, the Act in a way empowers the institutions to recover loans by auctioning those secured assets, predominantly the residential or commercial properties also, of the defaulters. So India's first ARC, that is Asset Reconstruction Company, was the RCL. So Asset Reconstruction Company of Company India Limited was established under the provisions of this Act. So just a second. Yeah. So moving on, the objective of the Act. Now typically as the chapter, as my sessions have been, I have been always considering the subject or the chapter the study material that has been provided by the institute, and accordingly I have in a way concised the entire study material into this PPT for the respective chapters as the session goes by. So objectives of this Act: empower secured creditors to take possession of secured assets without court intervention. That's the empowerment that has been given by the SARFAESI Act. It allows securitization or reconstruction companies to acquire financial assets from banks or financial institutions. It provides a legal framework for securitization activities in India, outlines the procedures for transfer of NPS to asset reconstruction companies, that is ARCs, for asset reconstruction, authorizes the banks and financial institutions to take over hypothecated or charged immovable property for debt recovery. It specifies three methods for NPA recovery. One is the securitization, second is the asset reconstruction, and third is the enforcement of security without court intervention. So these are the salient features or the salient objectives of the SARFAESI Act. The key definitions and terms that have been covered in the study material are about borrower, any person who has received financial, what you can say, just a second. Yeah. Any person who has received financial assistance or provided security, guarantee, mortgage, pledge for such assistance from a bank or financial institution, including borrowers of ARCs after asset acquisition or those raising funds via debt securities. So any person who has borrowed funds from the financial institutions against a particular security, that is called, he is called as a borrower. Debt as defined in the Recovery of Debts Due to Banks and Financial Institutions Act of 1993. It includes unpaid portion of purchase price for tangible, intangible assets under various contracts, and rights or interest in such assets used as security for credit. And third definition is that is covered in the study material is about Debts Recovery Tribunal, that is DRT. So tribunal established under the Recovery of Debts and Bankruptcy Act 1993 to adjudicate and recover debts due to banks and financial institutions. So this is how the Act has given the, so at least the study material has given these key definitions which I have tried to cover. Then comes the definition of default: non-payment of any debt leading to classification of the borrower's account as a non-performing asset. Also includes non-payment related to debt securities after a 90-day notice by a debenture trustee. So any non-payment of any debt that has happened will be considered as a default. And then comes the financial asset. So financial asset includes various forms of debts or receivables, secured or unsecured, rights in assets, tangible or intangible, mortgages, pledges, leases, and financial assistance. The financial lease, typically lease of tangible assets excluding negotiable instruments under an agreement where the lessee may own the asset after lease term or upon residual payment. So that's called as a financial lease. So in a way, Just a second. Yeah. So then comes the definition, or now, so these are the key definitions that have been covered in the study material. One is the borrower, then is the debts recovery tribunal, that is DRT, and default, what default means, and what is a financial asset, and what is meant by financial lease. Then comes the process that has been defined. So three acts which are there, three predominant processes. One is the securitization. Now securitization means pooling and conversion of financial asset, example loans into marketable securities, is what pooling and conversion of financial assets involves. Acquisition of assets by ARCs and fundraising via security receipts or other prescribed methods. So that's another process, and may involve custody of underlying mortgage assets. So these are the three key features of securitization, and which defines the securitization as a process. Then comes asset reconstruction. So asset reconstruction typically involves acquisition of rights or interest in bad assets by ARCs for realizing the financial assistance. Then involves converting NPAs into performing assets through various tools, example restructuring, sale or enforcement. The fourth is the asset reconstruction company. So a company registered with RBI under section 3 of SARFAESI to conduct securitization and or asset reconstruction. So the company which does the above two processes is called as the asset reconstruction company, and typically takes over NPAs from banks at discounted rates and manages their resolution. So these are the processes that has been defined in terms of securitization, asset reconstruction, and per se as asset reconstruction company, ARC. So the methods used for ARCs for asset reconstruction include taking over or changing management of the borrower's business, then sale or lease of part or full business, rescheduling of debt payments, enforcement of security interest, settlement of borrower dues, taking possession of secured assets. So these are the methods by which a asset reconstruction company can do the asset reconstruction. Then comes typically the role of RBI, because RBI regulates these ARCs. So RBI role in this entire SARFAESI Act is that regulation of the ARCs, conducts audits and inspections, can impose penalties for non-compliance with the regulations. So this is the rule of RBI under the SARFAESI Act. Then comes the non-performing assets. So a non-performing asset is a loan or advance where the borrower fails to make interest or principal payments for a specified period. It is classified by banks or financial institutions as substandard asset, doubtful asset or loss asset. So these are the classification is done as per RBI's guideline on asset classification and income recognition. So depending on IRAC, that is income recognition and asset classification, the NPAs or the typical bad loans are classified either as substandard asset or doubtful asset or loss of asset or loss asset. So these are the three categories which have been classified as into. The NPAs are classified either as a substandard asset or a doubtful asset or loss asset as per the guidelines that have been given by RBI on income recognition and asset classification. So other functions of a securitization or reconstruction company, so may act as an agent for banks or financial institutions to recover dues from borrowers for an agreed fee. So they can render securitization services in a way, acting as an agent to recover the dues from borrowers. Can serve as a manager for banks or financial institutions for a mutually agreed fee unless it results in pecuniary liability. may act as a receiver if appointed by a court or tribunal, cannot engage in any other business apart from securitization or asset reconstruction without prior approval. If involved in other businesses before the act's commencement, it must continue with them within 1 year of the act coming into force. Now comes the concept of enforcement of security interest. Upon default, the lender can issue a 60-day notice to the borrower and guarantor to pay the debt. If repayment is not made within 60 days, the lender can take possession of the secured asset, sell, lease or assign rights over the asset, appoint a manager to manage the asset, direct the borrower's debtors to pay dues directly to the lender. If there are multiple secured creditors, at least must agree for enforcement to proceed. These actions can be taken without court interventions under the Act are made. So this is how the enforcement of security interest is done under the SARFAESI Act. So, frankly, for the purpose of examination and in the study material, the entire Act has been given, or major sections of the SARFAESI has been given, and the valuation aspect has been covered in very few sections, which will come in the due course as we move ahead with the session. So just a second. So then comes the rights of borrower. So what are the rights of borrower? Borrower can object within 45 days of enforcement measures by filing the debt recovery tribunal. No pre-deposit required at first appeal stage. Second appeal to debt recovery tribunal, that is DRAT. The borrower must which can be reduced at the tribunal's discretion. So this is how in a way, the borrower has rights in terms of the enforcement measures by filing with the debt recovery team. So just hold on. Hello. Yeah. So moving on. So in a way, the borrower can object within 45 days of enforcement measures by filing with the Debt Recovery Tribunal (DRT), wherein no pre-deposit is required at the first appeal stage. However, at the second appeal stage, can be made to the Debt Recovery Appellate Tribunal, that is DRAT, but in that case the borrower must deposit 50% of the outstanding amount. However, such amount can be reduced to 25% at the tribunal's discretion. So then comes the concept called central registry, which has been prescribed under the SARFAESI Act. So what is meant by central registry establishment and functions? So so frankly, just a second. Yeah, sorry, there was this issue with the OBS. So anyway, so basically the need for central registry. So before that, let's understand what is central registry, establishment and functions. A central registry is created to regulate the securitization, asset reconstruction and security interest creation as such, headed by a central registrar. He maintains a central register where details of relevant transactions are recorded. These records can be maintained electronically. Particulars of transactions like securitization, asset reconstruction or security interest creation must be filed within 30 days. Yeah. Then such central registry requires particulars of transactions to be recorded, especially the securitization, asset reconstruction or security interest creation must be filed within 30 days. Then there has to be, if at all any modifications to the security interest, then those also must be filed within 30 days. So in case of satisfaction of security interest, that is when the loan is repaid, then those must be recorded within 30 days again. So earlier days, the entire details of securitization we used to be found on the Register of Companies website. But then because of the kind of amounts that were involved in these bad loans, it was decided to have a separate central registry to regulate the securitization and asset reconstruction and the security interest creation for such bad loans, so that a common repository is available for tracking the various assets that have been securitized or required to be reconstructed or required to be or any security interest creation is required. So satisfaction again has to be recorded within 30 days, satisfaction has to be recorded within 30 days, modification has to be recorded within 30 days. The particulars of the transaction of securitization, asset reconstruction or the security interest creation also has to be filed within 30 days. These records are open for public inspection on payment of certain fees. So that's how the central registry in a way helps the data. Then comes the need for central registry. This prevents fraudulent multiple lending against the same property. So typically the NPAs used to be turning out to be a bad loop, black hole in terms of money siphoning. So because of such central registry, the frauds have been prevented in terms of the same property against which multiple lending was happening. That was curbed or has been now prevented. It ensures transparency and helps verify charges on assets. So operational since 31st March 2011 as the Central Economic Registry. So this is the name of the registry now that is prevailing for the SURFICE Act. And precisely the whole purpose is to have the repository of the property that are being securitized with the various financial institutions and banks also, so that no multiple lending happens on the same property. So in a way, this registry allowed lenders and the public to check property charge status before transactions. And in a way, this central registry complements the charge verification system for companies under the Registrar of Companies. Then comes the benefits of central registry. Obviously, single source to verify asset charges.
Topics I have discussed are: what is Kanban? What is Kanban cards? Core practices of Kanban method. Benefits of Kanban. Let's start the video. Kanban is a Japanese word that means signboard or billboard. It is a workflow management method for defining, managing, and improving services that deliver knowledge work. It aims to help you visualize your work, maximize efficiency, and improve continuously. Originating from manufacturing, it later became a territory claimed by agile software development teams. Recently, it started getting recognized by business units across various industries. Toyota began optimizing its engineering processes based on a model that supermarkets were using to stock their shelves. Supermarkets stocked just enough products to meet consumer demand. The supermarket gained significant efficiency in inventory management by decreasing the amount of excess stock it must hold. Meanwhile, the supermarket can still ensure that the product a consumer needs is always in stock. To learn Kanban. Topics I have discussed are: what is Kanban? What is a Kanban board? Kanban cards, core practices of Kanban method, and benefits of Kanban. Let's start the video. Kanban.
Sorry, there was this issue with the PPT. Just a second. Yeah. So the benefits of central registry: typically single source to verify the asset charges. It helps trace charges on unregistered entities, example individuals, HUFs and association of persons. The benefit that one more was it reduced the fraud from fake title deeds or misrepresented ownership. It facilitated due diligence in securitization and property transactions. In a way, it protected the innocent buyers from fraudulent real estate practices. It made data on encumbered properties transparent. It assisted lenders in risk assessment due to better visibility on asset titles, and it minimized the bureaucratic delays and corruption related to land property transactions per se. Sorry guys, I'm just having my evening tea. So again, because of such a central registry of the data, it minimized bureaucratic delays. At the same time, it supported fair and transparency in the land record and financial system. So there was a connection properly set between the land records and the financial system also. Sorry, I guess this is a duplicate slide. Yeah. So, in a way, the SURFACE Act got updated of 2002. So, in the syllabus also, in the study material, there is a separate section on updated SURFACE 2002. So, I have picked up the summarized the entire study material which has been given in this. So, the objectives of SURFACE typically enable securitization and reconstruction of financial assets. It enforces security interests without court intervention and establishes a central database for property related and security interests. Section 31 Act not applicable to liens under the Indian Contract Act 1872 or Sale of Goods Act 1930. Pledges under Section 172 of the Contract Act. Security on aircraft or vessels. Unpaid seller rights under the Sale of Goods Act. Property is exempt from attachment under the CPC 1908. Security interest if less than 1 lakh or 20% of principal plus interest. And lastly, the agricultural land. So, Section 31 Act is not applicable to following categories of transactions. So again, the updated SURFACE Act 2002 gives the key definition as ARC. ARC is a company registered with RBI to conduct securitization or reconstruction. Asset reconstruction includes acquisition of financial assets from banks and FIs. Financial assets includes debts, receivables, mortgages and beneficial interest, etc. NPA account classified as substandard, doubtful or loss. Then securitization, typically ARC is acquiring assets, issuing security receipts to qualified buyers. Borrower, person granted financial assistance or who guarantees mortgages for the same. Default, non-payment of tax dues classified as NPAs. So Section 3 talks about registration of ARCs. So minimum net owned fund should be 100 crores. RBI assists the ARC's financial soundness, directors' qualification and compliance with the norms that have been prescribed by RBI. Then Section 5 of the Act prescribes acquisition of financial assets. So acquisition of financial assets can be done through agreement or securities, example debentures, stamp duty exempted for such transactions, and ARC becomes lender and inherits all rights of original creditor. Then under Section 5, legal proceedings continue in ARC's names post acquisition. Section 6 talks about the notice to obliger. Obliger notice must be served to borrower post acquisition and payment to ARC equals to Discharge of borrower's obligation. Section 7 talks about security receipts by ARCs. So ARCs per se can issue security receipts to raise funds from qualified buyers. They can maintain separate accounts per scheme, and qualified buyers, if more than 75%, more than or equal to 75%, can convene meeting to decide on non-realized assets. So section 9 measures for asset reconstruction, business management takeover, sale or lease of business, debt rescheduling, settlement, acquisition or conversion of debt to equity. Then section 13 talks about enforcement of security interest. No court intervention is required. 60-day notice is required to be given to the borrower after default. On failure to repay, creditor can take possession or management of secured assets, appoint a manager, redirect the debtors of borrower to pay secured creditor, and borrower can prevent asset sale by paying dues before public auction. Then comes section 14, which is the role of magistrate. So over here, the magistrate assists in possession of secured assets within 30 days, extendable to 60. Section 15 talks about takeover of management. So creditor can replace borrower's management via public notice. Directors, managers lose their position. Secured creditors appointee assumes full control. Post-debt equalization, management to be restored unless controlling interest acquired via debt to equity conversion. And miscellaneous provisions. So in miscellaneous provision there are 4 sections, typically section 16, which talks about no compensation to remove directors, managers. Section 17 talks about borrower may appeal to DRT within 45 days. Section 18 talks about appeal to DRAT, that is Debt Recovery Appellate Tribunal, within 30 days, wherein such borrower has to deposit 50% of the due or minimum 25% provided DRAT agrees to it. And section 20 talks about setup of SARSAI, that is Central Registry for registering security interest. So the typical central registry and registrar key provisions are: section 20 talks about it. Central government to establish a central registry with its own seal. The purpose is to register transactions related to securitization and asset reconstruction and creation of security interest. All lenders, bank, FIs, etc. must register security interest details with SARSAI within 30 days of creation. So these are the obligations which have been casted upon the banks and lending institutions and financial institutions, wherein if at all any particular loan has been given and any securitization or asset has been securitized against it, or a charge has been created, or any security interest has been created, then it has to be registered with the SARSAI within 30 days of creation. Or if at all any satisfaction or modification to the security interest, then that also has to be notified with the SARSAI. Section 21 talks about central government may appoint a central registrar to handle transaction registrations under the Act. Section 22 talks about the central register at the head office. At the head office, it will record details of securitization and asset reconstruction and security interest creation. maintained under the control and safeguard of the central registrar. Section 23 talks about all transactions related to securitization and asset reconstruction or security interest must be filed with the central registrar. Filing must be done within the prescribed manner and prescribed time and with prescribed fees. The central registry and registrar key provisions, section 26A, priority of secured creditors. After registration, dues to secured creditors takes precedence over all other debts, taxes and dues to any government authority. In case of solvency or in case of insolvency proceedings post IBC 2016, this priority is subject to IBC provisions. Obviously, the IBC prevails. Section 33, in a way, offenses by companies. So every person in charge of the company at the time of an offense is deemed guilty. Exception if they prove the offense was without their knowledge or they exercise due diligence. But that has to be proven to the court. If the offense was due to consent, connivance or neglect of any officer, director, manager, they are also held liable. So with this, the chapter ends on SURFICE. So it was a small chapter in the study material that has been provided by the institute, and in a way, the conceptual theory that has been provided in the study material I have tried to cover in a crisp, concise way. Now, as my practice had been, I will be covering the question and answers and the concepts that have been dealt with within those respective short question and answer and long question and answer. So in short question and answer 1, the objectives of SURFICE Act and addressing NPAs has been discussed. So in a way, it provides legal framework for securitization and asset reconstruction. It enables transfer of NPAs to asset reconstruction companies, allows banks to recover dues. Just a second. Yeah, allows banks to recover dues without court intervention and reduces the burden of NPAs and strengthens the financial systems, because in a way all the financial institutions and banks will always have non-performing assets. So non-performing assets are typical bad debts in a way for the bank, and obviously like any other business there are possibilities of bad debts and non-recovery of the dues. Similarly, banks has this kind of aspect also. However, in a way, to be able to manage these assets which are turning out to be bad or non-performing, a separate focused specialized entity or a special purpose vehicle has been created under the RBI regulations, and that is called as a ARC, Asset Reconstruction Company, or ASC, that is Asset Securitization Company. And in a way, the efforts, time, cost which is being spent by the bank on such bad loans or non-performing assets are in a way hived off to these ARCs, and then ARCs takes the care of the entire securitization aspect and the reconstruction aspect of those assets. Therefore, the burden of NPAs from the financial institution, lending institution, banks have been reduced thereafter, and thus it has helped strengthening the financial system. Then question 2 deals with the rights and responsibilities of the banks under SURFICE. So they can take control, they can take possession, sale or lease of lease collateral, can appoint managers to manage collateral, can instruct borrowers, debtors to pay directly to the banks, and enables faster and more efficient recovery. Then short question and answer 1 to 8 covers, so the short question and answer number 3 deals with key terms defined. So key terms that have been defined under that short question and answer 3 were securitization, that is selling financial assets to asset reconstruction company ARCs who fund through security receipts. Then asset reconstruction has been dealt with, wherein turning NPAs into performing assets via restructuring. And third aspect that has been defined in short question and answer 3 is the enforcement of security interest, which means recovery via possession or sale of collateral. Fourth, in question number 4, the role of RBI in regulating ARCs has been discussed. So ARCs typically grants, so RBI grants regular registration to ARCs. RBI frames rules, inspects ARCs and audits and imposes penalties. It ensures transparency and accountability in whole aspect of securitization and reconstruction of non-performing assets. So in short, question answer 5, the process of securitization and asset reconstruction has been discussed. So in securitization, the sale of assets to ARCs who raise funds from buyers, and asset reconstruction includes ARCs buy NPAs, restructure and recover them using various financial tools. So short question and answer 6 has dealt with the function and necessity of central registry. In that, it maintains records of securitization, reconstruction and security interest creation. It enhances transparency and prevents fraud in lending also. Then short question and answer number 7 has dealt with the concept of borrower safeguards. So what are the safeguards that are available to borrower, or in a way rights of borrower? So borrower has a right to object within 60 days of enforcement notice. He can appeal to debt recovery tribunal without initial deposit. In case of second appeal, then 50% deposit is needed. So in the overall scheme of things, the right of borrower has been ensured that a fair treatment during enforcement will be given to the borrower. So these are the borrower safeguards. Then comes the 8th concept, which is about critical evaluation. So critical evaluation involves effective critical evaluation of assets includes effective or is very effective for reducing the NPAs and helping banks recover dues. Criticism sometimes seen as favoring lenders over borrowers. Limitations doesn't cover all types of properties or loans also for that matter. So over here the short question and answer, typically 8 questions, short question and answers have been there, and that I have covered, and the concepts that are dealt with has been covered over there. Now comes the long question and answer. So total there are 5 long question and answers. The first long question and answer deals with how SARFAESI empowers financial institutions. So empowerment has been given to these financial institution banks by enabling asset possession and sale without court approval. For example, bank issues 60-day notice to the borrower. On failure, take over and sell the assets. So creation of ARCs allows discounted purchase and recovery of NPAs from the ARCs. Establishment of central registry enhances the transparency. So this is how SARFAESI has empowered financial institutions. The role of RBI has been discussed in long question and answer 2. Over here the role of RBI includes registers and regulates ARCs, conducts audits and inspections. RBI issues directions and penalizes non-compliances if at all anything has been done by in terms of RBI guidelines, and ensures responsible securitization practices. Third concept in the question and answer third has been dealt is about the methods of NPA recovery. So NPAs can be recovered by way of securitization, that is turning loans into tradable instruments by issuing security receipts. Asset reconstruction, ARCs convert bad assets to good ones. And in a way, third is the enforcement of security. So allows asset possession and sale which has been kept as security against the bad loans. So these are the methods of NPA recovery. The fourth question and answer deals with the concept of process of enforcement of security interest. So default typically triggers if 60 days repayment notice. On failure, lender can take possession, sell or lease the asset, appoint a manager, recover dues from third parties. Other options typically involved are the securitization or asset reconstruction.
Yeah.
Then long question and answer number 5, which is the last in the chapter, talks about the necessity and role of central registry. So over here, that central registry maintains centralized records of all charges on assets, mandatory for securitization, reconstruction and security interest, prevents fraud, ensures due diligence and protect buyers, boost confidence and transparency in the overall lending and financial system as such. So with this we come to an end of the chapter. I will do a quick recap of what all we have covered today in the today's session. So give me 2 minutes before I go. So we started with this chapter, which is a part of schedule section B, module 6, chapter number 4 or 6.4, which deals with salient features of SURFACE Act 2002 on valuation. So we started with the introduction to the Act, wherein the Act, in a way, the securitization and reconstruction of financial assets and enforcement of Security Interest Act 2002, SURFACE Act 2002 was enacted to help financial institutions manage and overall reduce the non-performing assets. It enabled banks and financial institutions to sell bad assets to asset reconstruction companies, ARC, registered with the Reserve Bank of India. The Act outlines detailed provisions for the formation and functioning of asset securitization companies and ARCs. The RBI regulates the activities of these companies. It provides legal mechanism for the protection of secured creditors like banks. The Act empowers institutions to recover loans by auctioning residential or commercial properties of defaulters. India's first ARC, RCL, was established under the provisions of this Act. Objectives: empower secured creditors to take possession of secured assets without court intervention, allow securitization or reconstruction companies to acquire financial assets from banks or financial institutions. It provides a legal framework for securitization activities in India. So these are the objectives of SURFACE. Outlines the procedure for transfer of NPAs to asset reconstruction companies for asset reconstruction, authorizes banks and financial institutions to take over hypothecated or charged mobile authorizes banks and financial institutions to take over hypothecated or charge immovable property or for debt recovery, specifies 3 methods for NPA recovery: securitization, asset reconstruction, enforcement of security without court intervention. Then we discuss the key terms and definitions typically. So borrower, any person who has received financial assistance or provided security, guarantee, mortgage or pledge for such assistance from a bank or financial institution, including borrowers for ARCs after asset acquisition or those raising funds via debt securities. Debt, as defined in the Recovery of Debts Due to Banks and Financial Institutions Act 1993, includes unpaid portion of purchase price for tangible or intangible assets under various contracts, and secondly, rights or interest in such assets used as security for credit. Debts Recovery Tribunal, that is DRT, tribunal established under the Recovery of Debts and Bankruptcy Act 1993 to adjudicate and recover debts due to banks and financial institutions. Then we discuss the term default. The typical default means non-payment of any debt leading to classification of the borrower's account as a non-performing asset. Give me 2 minutes. So non-payment of any debt leading to classification of the borrower's account as a non-performing asset also includes non-payment related to debt securities after 90-day notice by a debenture trustee. The financial asset typically includes various forms of debts or receivables, secured or unsecured, rights in assets, tangible or intangible, mortgages, pledges, leases, and financial assistance. Financial lease, typically lease of tangible assets excluding negotiable instruments under an agreement where the lessee may own the asset after lease term or upon residual payment. Process defined, typically securitization includes pooling and conversion of financial assets, example loans, into marketable securities. So it involves acquisition of assets by ARCs and fundraising via security receipts or other prescribed methods. May involve custody of underlying mortgage assets. Then comes the asset reconstruction. So over here, acquisition of rights interest in the bad assets by ARCs for realizing the financial assistance. Involves converting NPAs into performing assets through various tools, example restructuring, sale or enforcement. Asset reconstruction company typically includes, ARCs includes are a company registered with Reserve Bank of India or Section 3 under Section 3 of SARFAESI to conduct securitization and or asset reconstruction. It takes over NPAs from banks at discounted rates and manages their resolution. So that's how the asset reconstruction company came into existence under RBI mandate. Then we saw the methods used by ARCs per se for asset reconstruction, taking over or changing management of the borrower's business. So these are the various methods by which asset reconstruction can be done: sale or lease of part or full business, rescheduling of debt payments, enforcement of security interest, settlement of borrower dues, or taking possession of secured assets. Then we saw the role of RBI under the ARCs typically and our SARFAESI. So RBI regulates ARCs, conducts audits and inspections, and RBI can impose penalties for any non-compliance with the specific regulations about ARCs. Then we saw NPAs. So what is meant by NPA? NPA is a loan or advance where the borrower fails to make interest or principal payments for a specified period. It is classified by banks or financial institutions as substandard asset, doubtful asset, or loss asset. The classification is done as per RBI's guideline on asset classification and income recognition. The other functions of a securitization or reconstruction company may act as an agent for banks or financial institutions to recover dues from borrowers for an agreed fee, can serve as manager for banks or financial institutions for a mutually agreed fee unless it results in pecuniary liability, may act as a receiver if appointed by a court or tribunal, cannot engage in any other business apart from securitization or asset reconstruction without prior RBI approval. If involved in other businesses before the act's commencement, it must discontinue them within 1 year of the act coming into force. Enforcement of security interest. Upon default, the lender can issue 60-day notice to the borrower and guarantor to repay the debt. If repayment is not made within 60 days, the lender can take possession of the secured asset, sell, lease, or assign rights over the asset, appoint a manager to manage the asset, direct the borrower's debtors to pay dues directly to the lender. If there are multiple secured creditors, at least 75% must agree for enforcement action to proceed. These actions can be taken without court intervention if conditions under the Act are met. Rights of the borrowers were discussed. Then borrower can object within 45 days of enforcement measure by filing with the Debt Recovery Tribunal, that is DRT. No pre-deposit required at first appeal stage. For second appeal to Debt Recovery Appellate Tribunal, that is DRAT, must deposit 50% of the outstanding amount, can be reduced to 25% at the tribunal's discretion. So thereafter we saw the central registry, that is a SARFAESI in a way establishment and functions. The central registry is created to regulate securitization, asset reconstruction and security interest creation, headed by a central registrar. Maintains a central register where details of relevant transactions are recorded. Records can be maintained electronically. Particulars of transactions, securitization, asset reconstruction or security interest creation must be filed within 30 days. Modifications or security interest must also be filed within 30 days. Satisfaction of security interest when the loan is repaid must also be recorded within 30 days. Records are open for public inspection on payment of certain fees. The need for central registry, in a way we understood, prevents fraudulent multiple lending against the same property, ensures transparency and helps verify charges on assets. Operational since 31st March 2011 as the central electronic registry, allows lenders and the public to check property charge status before transactions, complements the charge verification system for companies under the Register of Companies. Benefits of the central registry: single source to verify asset charges, helps trace charges on unregistered entities, individuals, HOFs and AOPs, reduces fraud from fake title deeds or misrepresented ownership, facilitates due diligence in securitization and property transactions, protects innocent buyers from fraudulent real estate practices, makes data on encumbered properties transparent, assists lenders in risk assessment due to better visibility on asset titles, minimizes bureaucratic delays and corruptions related to land property transactions, supports faith and transparency in the land record and financial system. Then we saw the updated SARFAESI Act 2002. Objectives of the SARFAESI Act: enable securitization and reconstruction of financial assets, enforce security interests without court intervention, establish a central database for property related and security interests. Section 31 states that the Act is not applicable to liens under Indian Contract Act 1872 or Sale of Goods Act 1930, pledges under Section 172 of the Contract Act, not applicable to the security on aircraft or air vessels. Unpaid seller rights under Sale of Goods Act, properties exempt from attachment under CPC 1908, security interest if less than 1 lakh or less than 20% of principal plus interest, agricultural land. For these types, Section 31 says that the Act is not applicable at all. So the key definitions again: ARC, company registered with Reserve Bank of India to conduct securitization and reconstruction. Asset reconstruction includes acquisition of financial assets from banks, FIs. Financial asset includes debts, receivables, mortgages, beneficial interest, etc. NPA account classified as substandard, doubtful or lost. Securitization includes ARC acquiring assets, issuing security receipts to qualified buyers, borrower, person granted financial assistance or who guarantees mortgages for the same, and default means non-payment of dues classified as NPAs. Then we saw Section 3 which talks about registration of ARCs. So minimum net owned funds should be 100 crores. RBI assesses ARC's financial soundness, directors qualification and compliance with norms. Section 5 talks about acquisition of financial assets through agreement or securities, example debentures, stamp duty exempted for such transactions. ARC becomes lenders and inherits all rights of original creditor. Legal proceedings continue in ARC's name post acquisition. Section 6 talks about notice to obliger. So notice must be served to borrower post acquisition. Payment to ARCs equals discharge of borrower's obligations. Section 7 talks about security receipts by ARCs. ARC can issue security receipts to raise funds from the qualified buyers, maintain separate accounts per scheme. Qualified buyers, if more than 75%, can convene meeting to decide on non-realized assets. Section 9 measures for asset reconstruction. So business management takeover, sale or lease of business, debt rescheduling and settlement, possession or conversion of debt to equity. Enforcement of security interest, Section 13 deals with it. No court is required, no court intervention is required. 60-day notice to be given to borrower after default. On failure to repay, creditor can either take possession or management of secured assets or redirect the debtors of borrowers to pay secured creditor, or borrower can prevent asset sale by paying dues before public auction. Then section 14 deals with the role of magistrate. So CMMM, DM assist in possession of secured asset within 30 days, extendable to 60. Section 15 talks about takeover of management. Creditor can replace borrower's management via public notice. Directors or managers lose their position. Secured creditors appointee assumes full control. Post-date realization management to be restored unless controlling interest acquired via debt to equity conversion. Miscellaneous provisions included were section 16, no compensation to removed directors or managers. 17 talks about borrowers may appeal to DRT within 45 days. 18 section appeal to DRAT within 30 days, deposit 50% of due or minimum 25% at least. Section 20 talks about setup of SARSAI, that is Central Registry for registering security interest. The Central Registry and Register key provisions, section 20 talks about it, and central government to establish a central registry with its own seal. The purpose is register transactions related to securitization, asset reconstruction and creation of security interest. All lenders, banks, FIs, etc. must register security interest details with SARSAI within 30 days of creation. Section 21, central government may appoint a central registrar to handle transaction registrations under the Act. Section 22 deals a central register shall be maintained at the head office. It will record details of securitization, asset reconstruction and security interest creation maintained under the control and safeguard of the central registrar. Section 23, all transactions related to securitization, asset reconstruction or security interest must be filed with the central registrar. Filing must be done as per prescribed manner and fee. Section 26E talks about priority of secured creditors. Now in this, after registration, dues to secured creditors take precedence over all other debts, taxes and dues to any government authority. In case of insolvency proceedings post IBC 2016, this priority is subject to IBC provisions. Section 33, offences by companies. Every person in charge of the company at the time of offence is deemed guilty, exception if they prove the offence was without their prior knowledge or they exercised due diligence. If the offence was due to consent, connivance or neglect of any officer, director or manager, they are also held liable. Then we saw various question and answers that have been given under the chapter in the study material provided by the institute. In that short question and answer, one deals with objectives of SARFAESI Act and addressing NPAs. Therein it covers, provides legal framework for securitization and asset reconstruction, enables transfer of NPAs to asset reconstruction companies, allows banks to recover dues without court intervention, and reduces burden of NPAs and strengthens financial system. Then we saw rights and responsibilities of bank. So in that, RBI banks can take possession, sale or lease collateral. They can appoint managers to manage collateral, can instruct borrowers, debtors to pay directly to the banks, and enables faster and more efficient recovery. The key terms that were discussed in question and answer 3, short question and answer 3, were securitization, which means selling financial assets to ARCs who fund through security receipts. Asset reconstruction per se means turning NPAs into performing assets via reconstruction, or restructuring, and enforcement of security interest, which includes recovery via possession and sale of collateral. So role of RBI in regulating ARCs: typically grants registration to ARCs, frames rules, inspects ARCs, audits and imposes penalties, ensures transparency and accountability also. Then we saw the process of securitization or asset reconstruction. Securitization includes sale of assets to ARCs who raise funds from buyers, and asset reconstruction includes ARCs buys NPAs, restructure and recover them using financial tools. Function and necessity of central registry: maintains records for securitization, reconstruction and security interest creation, enhances transparency and prevents fraud in lending. Borrower safeguards: right to object within 60 days of enforcement notice, can appeal to debt recovery tribunal without initial deposit, 50% deposit needed for second appeal, ensures fair treatment during enforcement. Critical evaluation includes effective for reducing NPAs and helping banks recover dues. Criticism sometimes seen as favoring lenders over borrowers, and limitations doesn't cover all types of properties or loans. Then we saw how SARFAESI empowers financial institutions. It enables asset possession and sale without court approval. Example, banks issue 60-day notice on failure, take over and sell the assets. Creation of ARCs allows discounted purchase and recovery of NPAs. Establishment of central registry enhances transparency. The role of RBI includes registration and regulation of ARCs, conducts audits and inspections, issues directions and penalizes non-compliance, ensures responsible securitization practices. Then methods of NPA recovery involve securitization, that means turning loans into tradable instruments, asset reconstruction, ARCs convert bad assets to good ones, enforcement of security allows asset possession and sale. Process of enforcement of security interest includes default trigger 60-day repayment notice. On failure, lender can take possession, sell or lease the asset, appoint a manager, recover dues from third parties. Other options include securitization or asset reconstruction. Then the last question dealt with necessity and role of central registry. So it maintains centralized records of all charges on assets, mandatory for securitization, reconstruction and security interest, prevents fraud and ensures due diligence and protects the buyers, boosts confidence and transparency in lending system. So with this we end the session and the chapter also. So by now in a way we have finished with the section B, module 6, in that the chapter 4. So the last chapter which will be covered in the next session talks about valuation standards. So international valuation standards have been prescribed for the purposes of business valuations. So in the next session we will see what all is included in this chapter 5, which is about valuation standards. So it's almost 8:30. We'll stop for the day and see you in the next session, which is on Thursday. So Rakesh, so unless and until typically nothing is intimated on the group in terms of that the session will not happen or has been scheduled on another day, you need not ask every Tuesday and Thursday whether the session is going to happen. The session will be always there on Tuesday and Thursday, which is my day or my scheduled day, and it will start at 6:30 to 8:30. So that's how it is. So you can log in and check. Mostly I haven't missed any session or the day also. So for the time being we'll stop for the day and see you in the next session. Signing off yours, CACS Pushkaraj Vishnu Joshi. See you in the next session. Any queries, doubts, Anu or Rakesh you have on this chapter? Good to go? Good to end the session? Okay. Thank you. Thanks. See you. Bye-bye.